Perfect. Okay. Well, thank you very much. I really appreciate that introduction, and I hope I won't disappoint. Let me start by saying I agree with absolutely everything that Scott said, but following the pattern of this morning where the first speaker says, hey, look at all the things that are changing, I'm going to be the person that says, yeah, but. With that, I will be talking from notes only because I am going to get a little bit into the weeds. And so it's important that I kind of go through things in order. So my primary area of expertise really is electricity, and that a lot of the discussion will focus on that as opposed to focusing on the gas and oil pipeline side as much, although I will mention those. I will say that in the law school, we teach energy and environmental law as being at the intersection. And because the reality is you cannot harness and produce and harness electricity or any kind of energy source without having some environmental impact. So the question is, where do you find that sweet spot where it's the least impactful? And so even as we move forward and worry about greenhouse gases, we also, of course, have to worry about land use and waste disposal and recycling and the full life cycle of the products that we're looking at. And so as we teach and as I think about these issues, that's always kind of at the back of my mind is what is this big picture? How do we look at both the energy side and the environmental side? Let me just make sure I have a timer going here too. Because the industry is highly regulated, most of the kinds of disputes I see primarily go first to an administrative agency, whether it's the Federal Energy Regulatory Commission or a state public utility commission. Here in DC, we call that the Public Service Commission. It goes by different names in different states. Illinois calls theirs the Illinois Commerce Commission. But then after that, they may go up to courts as a matter of judicial review. In contrast, the kinds of cases that go first to the trial courts, where you would have a dispute being resolved on the basis of evidence and the finder of fact being your trial court, tend to be a little bit more remote in my area, not exclusively. And we'll talk about some cases in which people have tried to bring cases in multiple different forums in order to be able to find that one that will be the breakthrough for them. I also want to note that a lot of the cases that you hear a lot about really are more about environmental law than energy law. That is, we hear cases about pipelines, for example, and the impacts they're having and the efforts to stop them. Often those are based on NEPA or other types of environmental concerns. And so I really won't be talking about those here because I really do want to focus on the ins and outs of energy law. What's really important to understand about energy law is that it is not about protecting the environment. It's not even about protecting consumers. It's about delivering the energy resource in a way that meets the public interest. And that has historically been defined as a balancing issue. So we have a regulatory structure that is both meant to create monopolies in a large extent, at least as they were originally formulated, in order to be able to protect investments being made in a very capital intensive industry, so that that industry would be able to then meet the needs of the greatest number of people at an affordable cost. And then the flip side of that, of course, was the regulator would regulate prices in order to be able to protect the consumers from that monopoly power that was state granted. So it's a very different regulatory structure, and it's all built on this balance, part of which is to protect the providers of the service, as well as to protect the consumers of the service. So as I talk today, I'm going to spend some time on jurisdictional conflicts, which is kind of weedy, I understand, but it is really actually important as we understand this, because as Scott pointed out, a lot of what is happening, a lot of what is moving the industry is happening at the state level or at the local level. And we have to look at how that conflicts with the federal authority and where, again, where that balance is. One of the things also, of course, is that laws are always written in context. That is, we have a vision of what the world looks like and we write laws based on what we know. So one of the things that's important to understand about the world of energy is there's really three different layers, and you have to sort of think about them separately sometimes to really understand how it all works. There's the physical side, and Scott explained to you physically all these different things that we can do, how this item will work with that item. you know, how we can connect wind and combine it with storage and therefore be able to meet energy needs. That's all very physical. There's the transactional and the commercial. Where's the money coming from for the investment? Who's going to buy this? How much is it going to cost? Who's the buyer? Who's the seller? What's that transaction look like? And the reality of the electric system in particular is that it all moves together in an AC system. There's no direct transactions that are happening at a physical level. So for example, if I, for example, am selling wind power and Randy is selling coal power, because we know he wouldn't, and Leslie is going to buy the power, she may make a contract with me for wind power, but I'm going to put my power into the same system that Randy puts into his, and what goes into her house is just going to be whatever's in the system. So transactionally, Leslie and I have a contract. Physically, what's happening is it depends on what the entire system is configured like. So there's always that little bit of a break. And then the third layer is regulatory and jurisdictional. And this is the part where Scott says, yes, we can do this. We've got all these amazing things. We can find the investors. People really want to build this stuff. Everyone's really excited about it. And then the law and regulatory system says, not so fast. And the reason in part is because if we think about how we got to the regulatory system we have today, the Federal Power Act, which is the federal level, sort of the main one for regulating electricity, was signed into law in 1935. So if we think about physically what the system looked like in 1935, you essentially had, does this have a little pointer thing? Maybe. Oh, yeah. So you had generation, you transmitted it, you distributed it, and at the end, someone consumed it. Very linear, very organized. But if you thought about what was happening transactionally, what was usually happening, because at that point, we pretty much had centralized systems where the generation all the way down to the meter was owned by the same utility. Within each utility, you would have, they would own the generation, they'd transmit it, they'd sell it. And the biggest transactions at a wholesale level were from utility to utility. So utilities might exchange power, but that was really all that was happening between utilities. Most of it was within individual utility systems. Not entirely true, but mostly true. So just want to make sure I'm going through all the pieces here I need to. So if we think about the energy transition, so first of all, let's define that as thinking about moving from a system that is primarily fossil fuel to one that is more mixed, greater proportion of either low emitting or zero emitting energy resources. As we move, well, actually, let me back up here a minute. So here we are, we're in pre-1930s. This is more like the 1920s. It's looking like this. The only kinds of transactions that we're seeing here, utility. Up until that point in time, what was happening at the utility system was being regulated by the states. The states within their police powers could be able to set rates and regulate the utilities. When these transactions began happening between utilities, let's take, for example, one that happened in the mid-1920s, just for example, where a utility in Rhode Island was selling power to its own residential customers, wanted to make a sale to the utility in Massachusetts, Attleboro Steam and Electric Company. It did so, it set the rate to do it by contract, and then its regulator in Rhode Island said, wait a minute, you need to, if you want to charge more to your local ratepayers to cover their costs, you have to also raise the rate you're selling into Massachusetts. And Attleboro sued and said, no, you can't do that. You're the Rhode Island regulator. You can't regulate my contract. And it went up to the Supreme Court, and the Supreme Court said, yes, you're absolutely right. There is no ability for the state to regulate that transaction. And so what ended up happening was we got the Federal Power Act. It was meant to cover that gap. And so the Federal Power Act gives to the Federal Energy Regulatory Commission a very limited set of jurisdictional obligations. It regulates wholesale sales and transmission and interstate commerce. And it says explicitly that generation is left to the states. and that generation, all other kinds of sales are within the realm of the state. So retail sales, states. Wholesale sales, FERC. But as we move forward in time and we come this beginning of this electric system transmission, we get to the point in the 1990s where FERC said, wait a minute, this is not the best system we could have. Those individual utilities, some of them are charging 17 cents. The one next door is charging 6 cents. People who have cheap power can't get it to the utilities that want to buy it because they're being blocked by the use of the transmission system. And so FERC required that all utilities open up their transmission systems to anyone who wanted to use them for prices that were comparable to the way they treated themselves. And they also created these things called RTOs, or regional transmission organizations. In some parts of the country, they're still called independent system operators. And these entities often operated organized or they now all operate organized markets. Initially, it sort of began creeping forward that way. And the difference here is that now you have all kinds of different entities that are selling power from different kinds of plants owned by different entities, and they're all selling into this RTO market. And then the people who are using the electricity over here are buying out of that RTO market. So the benefit of this is you're supposed to be able to do this much more efficiently. You have all the generators selling in, and then you should be able to extract from the market at comparable prices and be able to use the power more efficiently. So just want to make sure I hit the, okay. So if we look at where these RTOs are, they do not cover the entire part of the country. But they do cover most of the parts of the country where most of the population lives. And so as a practical matter, they affect the prices and the operations for most of the country. So with that kind of background, I now want to shift into kind of what has been happening on the legal side and why this jurisdictional split that I'm talking about is important and how these RTOs end up operating. A lot of what FERC does, it does by operating through setting the rules in the RTO market. So that's how it regulates that part of the market. People offer to sell power into the market. They run on a bid-based system. The operator of the market will take the lowest cost bids, stack the bids, whoever figures out how much it needs, and then whatever the market clearing price is, that is the last bid accepted, everyone in the market gets that price. So we get back to the question again about states. Now, as you remember, I said the Federal Power Act said that states continue to retain power over, continue to retain jurisdiction over generation. So the first case I'm going to talk about actually doesn't involve renewables. It involves gas-fired generation. In these RTOs, one of the things that happens is that as the power is being bid in and allocated to the different users, again, ideally, the entire RTO would have the same price. But the reality is you have to have transmission to move that power. And so if you have a constraint, you end up with a price split. Now, in this particular slide, just happened to pull it off the last week, we're actually seeing here higher prices over here in lower prices over here in Maryland and New Jersey. But about 10 years ago, that was not the case. What was usually happening, the higher prices were over here in New Jersey and Maryland. And so those two states decided they want to create an incentive system to get more people to build capacity in that part of the RTO system. And the reason why they wanted to do this was because if you had more lower cost capacity, then you would be able to lower the price in that part of the system, notwithstanding the transmission constraints that were otherwise preventing low cost power from getting to them. So they put together a scheme in which they offered a contract for differences. And underneath this contract for differences, the people who agreed to build new generation would be assured a certain level of price. So this meets the transactional need for investment. They would still be required to participate in the RTO market. However, if they didn't earn enough in the RTO market, this contract for differences would effectively make sure that they met their need. And then if they earn more in the RTO market, they would actually pay it back. Great system. one of the problems with that is that when you do that, you're forcing down the price in the RTO system. That is, you've got some more capacity coming in, more supply. They're going to be bidding in. In the meantime, you've also got pressure from all these renewables that are low cost. All of this is pushing down the price. So the competitors in the same market said, this is an impermissible action by the states intruding on the jurisdiction of the Federal Energy Regulatory Commission to set wholesale rates. And so they argued that, essentially that this was an action that should have been preempted by the federal jurisdiction. And they actually won on that. It went up to the Supreme Court after several trips through. And the court did agree, but they said something really important in their decision that I want to read to you. They did, somebody wiggle. Okay, so they said, we reject Maryland's program. The two cases went together, but they talked in particular about the Maryland program. So they says, we reject Maryland's program only because it disregards an interstate wholesale rate required by FERC. We therefore need not and do not address the permissibility of various other measures states might employ to encourage development of new or clean generation, including tax incentives, land grants, direct subsidies, construction of state-owned generation facilities, or re-regulation of the energy sector. Nothing in this opinion should be read to foreclose Maryland and other states from encouraging production of new or clean generation through measures untethered to a generator's wholesale market participation. So as long as the state does not condition payment of funds on capacity clearing the auction, the state's programs would not suffer from the fatal defect that rendered Maryland's program unacceptable. Okay, so perfect, right? No blurriness left. Ha. So let's just take a minute here to take a look at PJM. So here's the fuel mix again. As of last week, I just pulled it off. This changes all the time. This is a kind of 5-minute snapshot. But if we look at that top slot, that big gold section there, is the portion that's being actually, I guess it's kind of brownish. That's what's being provided by nuclear. So that's a big chunk of the market. The light blue section is gas. You see coal's got about 25%, pretty much about the same as nuclear. And then we have renewables. This one here breaks out the renewable mix. You can see most of that's hydro, although we do have some wind, solar. But when you look at that, one of the things that's very evident is that a lot of what's being used right now in PJM is coming from fossil fuels. And what's also evident is that nuclear is a very important piece. Well, going back to the way that whole market works, when you have that clearing price, everybody's got to be able to make enough money to be able to use that clearing price effectively. And the nuclear plants were finding the ones in nuclear, and this is really true across the country, the ones that are in competitive markets were not earning enough money, because what was happening at this point in time, this is about 5-6 years ago, you had renewables coming into the market, pushing down the price. You had a lot of very cheap gas-fired generation because fracking had driven down the cost of gas. And so the market prices were relatively low, and they were such that the nuclear plants could not recover their costs. So both New York and Illinois decided they would address that by creating state incentives for retaining the nuclear plants. The nuclear plants wouldn't shut down. So they created something called zero emission credits. Now, if you're familiar with the renewable energy market, there's something called renewable energy credits. When you generate a megawatt, actually, I guess, yeah, based on megawatt hour of generation from your solar or wind facility, you get something called a renewable energy credit, and those have value. They're state created, but they can be sold. And so, for example, utilities will be told they have to have so much of their generation coming from renewables, either because they've bought it directly or because they're showing that they have renewable energy credits. So they created the same kind of a system for zero emission credits coming from nuclear. Now, many years ago, FERC had disclaimed jurisdiction over renewable energy credits. They said, no, that's a separate product. It's not, as long as it's not being bundled with the sale of electricity at wholesale, it's not our business. That's okay. So following that same model, Illinois and New York came up with a zero emissions provision. And again, the existing generators decided this was pushing down the prices again too much. These are mostly gas-fired existing generators that were bringing these cases. And so they went to the courts and said, no. You're once again messing with the market. Now, the way these zero emission credits were valued, there was a component that did look to what the price was in the market, but it would look about every 2 years. They were actually tied more to the social cost of carbon. So it wasn't a direct requirement that the entity participate in the RTO market, but there was a tie there. So what do you think happened? Goes up to the Supreme Court. Existing generators are saying, no, this treads on FERC's jurisdiction, just like the Talon case, the one we just discussed. You got to throw this one out. It's preempted by federal law. No, this one flew. This one was a permissible state setting of the rates. So at this point, you might think that we're all done with this problem. You're wrong. Round 3 is now in the Third Circuit. So those two cases were in the Second and Seventh Circuit. They didn't make it up to the Supreme Court, the ZEC cases. But in the Third Circuit case, we're now going back to FERC and trying to change the market rules. So the current market rules allow these kinds of state incentives to be, FERC is basically saying they don't conflict with our rules. This can come into the market. And the same group of competitive generators are challenging that and saying, no, this was not passed appropriately. It was actually deadlocked. And so it went into effect without an actual FERC vote on it. But they're also arguing that it's impermissible rulemaking. So we'll see where that comes out again. But here you have the struggle of the states attempting to change this fuel mix and this problem of the jurisdictional limitations on the ability to do that. I'm going to skip through that just for time reasons. Let's see. I do also want to, well, actually, I was asked to talk about transmission lines. So let me touch on that because we also do have another jurisdictional transmission line issue. So the other problem that we're seeing is the construction of transmission lines. In order to be able to realize that vision that Scott laid out of all of this wonderful of wind and solar generation, we are really dependent on being able to move that power from where it is being generated to where the load centers are. So if we were to try to do that, we need to have more transmission lines. Of course, these raise environmental issues, but it also raises the question of who is going to make that investment. And the ways in which transmission lines get built. If a utility, for example, wants to build one, they want to connect it to their own system, they can go try to get recovery, both from FERC for the wholesale sales that they'll make off of that line, get the state permitting process. But in addition, there's also now these RTOs who are sometimes identifying needs for transmission lines and saying, we see that we need to have one from here to here. And there is a group of people that are independent providers of transmission service that would like to get involved in this market and build those lines because it's a regulated market. It can be relatively lucrative. But the question is who gets to do the building? And so several years ago, FERC had put together they had an order 1000. Prior to that, the utilities had a right of first refusal to build the line. So if somebody said, I want to build a line through Kansas, the Kansas utility could say, oh, I'll do that, and preclude anybody else from doing it. That was done away with. And so the idea being now that when the Mid-Continent Independent System Operator decided that it needed some lines running into East Texas, for example, it said, here's what we need. Next era said, hey, I'll build those. They were not the incumbent utility, no problem. Except that when they hit the Texas border, Texas says, we still have a right for the incumbent utility to have a right of first refusal. And so again, we had another jurisdictional battle. And in this case, this one actually went to state court, and they upheld the right of the Texas utilities to have that ability to build. So again, that line is not being built presently. That one just came out of the court. It was an unreported decision. So those are some of the battles we're seeing at that point and trying to change that the mix. The other thing that's happening that is also an impediment here is if we think about also what was happening in terms of generation, not only do we have all these new kinds of generation coming in on the side over here where things flow into the central market, we're also now seeing a lot more of generation on the distribution side. It's actually happening on the distribution grid. So this, of course, again, contradicts what the Federal Power Act was thinking about when it built these things. Who's going to have jurisdiction over what happens with things happening on the distribution side of the grid? Their ability to participate in the wholesale market. So say, for example, I want to actually sell my power to the wholesale market. It's got to be able to cross that distribution grid. One of the products that's really valuable, in particular on that side of the grid, is the ability to limit what we use. If you think about the fact that generation has to be pretty much in balance, that is, we have to generate and or store electricity at, and then we have to use it as we generate it, subject to whatever we can store. Then you have to be able to keep that grid in balance at all times. And one way you can do that is to generate more. The other way you can do that is to use less. So a product called demand response is a valuable product. And one way you can do this is you can aggregate. You've probably heard, on hot summer days, you'll hear an appeal going out saying, could you please use less? We expect a peak day tomorrow, and so we need to have you use a little bit less electricity. And certainly on a voluntary basis, people do that. But it can also be purchased. You can have aggregators. It might be your utility, it might be a third party who pays you to reduce your energy usage. And then taking all of that reduced energy together, they can create a product, demand response, and they can bid that into the RTO market. And FERC came out with a rule that said, you know what, that's every bit as valuable as generation. As Scott said earlier, the best electricity is the electricity you don't use. So you have people using less electricity. It could be used as a substitute for generation. And so FERC says if someone wants to sell that into the market, they may. And furthermore, they have to be paid exactly the same amount that you would pay for the generation. So do you think anybody had problems with this? We want to take a guess who had problems with it? Of course, the existing generators, same group. A lot of this was being led by the Electric Power Supply Association. They're the petitioners and or plaintiffs in several of these cases. So they went to FERC and said, hey, wait a minute. We've just been through these cases, the Talon case, the one with the gas-fired generators. We've been through the ZEC case. The states, or it wasn't here. Oh, excuse me. Here, the problem was not that the states did it. This was the fact that FERC itself was doing something. But they said, FERC is treading on the territory of the states. It's up to the states to decide. And FERC can't require this. So in this case, again, FERC actually upheld this rule too, because they said in this case, what FERC had done was they said states don't have to allow participation. If the state decides to allow their people on their distribution grid to participate in the market in this way, then all we're doing is we're setting the rule for how they participate once they're in the market. And so it did not cross that jurisdictional line again. But this time here, it was the ability of FERC to say, we're only regulating our market. We didn't intrude on the jurisdiction of the states. So as we think about how this transition is going to unroll, and we think again about all of these state policies that are going to be important to making this change, we have to keep being conscious of where that line is. How far can the states go in demanding that states implement a certain kind of generation and subsidize it? The subsidy is the really important piece here, to the extent that it's cost effective. And as Scott pointed out, a lot of these new technologies really are. When utilities are going to their commission and saying, I want to put in some more generation, often wind is the low cost option, or more and more so these days, solar. And so in those cases, that doesn't raise these sorts of subsidy issues. But once that subsidy comes into play, then you do have this problem of what is the impact on the federal market and who gets to make that call? Is it dependent on what the states would like to see this fuel mix look like? Or does it impair FERC's ability to be able to regulate that market? I'd like to touch a little bit on net metering because Scott said I would. So first of all, the concept of net metering, I think you're all pretty much aware, is that when you generate electricity, you can think of it in a couple of ways. One is that you are just generating to the grid and then taking power off the grid. And even for people that say, oh, I'm completely self-sufficient, realistically, what's happening is you might be generating more during the day and then taking power off the grid at night, such that, say, over the course of the month, you've supplied all of your power, but not on a moment-to-moment basis. So you still need that distribution system to be connected to your house in order to be able to make that happen. So a couple of different issues are happening, or a couple of different controversies that are arising around this. Scott alluded to one of them. One is, how much do you pay for that distribution system? In both DC, a lot of the states that have competitive power, that is in DC, and I think it's now also the case in Virginia, and it's also the case in Maryland, I can choose who I want to buy my power from. Now, again, as we talked about before, when Leslie says she's buying her power from me, realistically, she's getting whatever goes into the grid. But I can still say that, you know, I'm providing wind power and she can feel good that she's buying wind power. And that means that I am putting wind power into the grid. It just isn't flowing directly to her house. So when we think about net metering, you're putting power into the grid at some point, you're taking it out, and then the idea from a homeowner's perspective is, well, really, I should be getting paid exactly as much as I bring in. I should be getting paid the same amount as what I pay for what I have brought in. In some states, this is coming into controversy because one of the concerns is what is actually in that amount. You know, for some states, it's bundled together with the distribution cost. And so that's one of the issues. In states like DC and Maryland and Virginia, less so, because I, for example, pay for my distribution and transmission service separately from the amount that I pay for my energy service. Although I have to say in DC, it's very generous. I actually get the credit back also on my distribution service. And I'm not really sure why that happens, but I'm living with it. So a lot of those cases in which they think about that, they are not really thinking also about the other values that come with solar power. So for example, the value of the fact that it is not generating greenhouse gases. So there's been this idea of a value of solar tariff that has come up in several places. Minnesota was really excited about this a number of years ago. The utility in particular said, yeah, we're not going to pay the same retail price that we sell power at. We're going to get a value of solar tariff. We think it's going to be less. They were a little bit surprised when, after all of the negotiations were done and the social cost of carbon got rolled into it, that is actually higher. So as the utility says, that didn't come out the way we thought. So that's one of the battles, is how much should utilities actually be paying for that power that homeowners are generating. The other one is about how much they should be charging for transmission and distribution service. And as he pointed out, Salt River was kind of the leader in this. They said, yes, these folks are putting a burden on the distribution system. People are trying to take themselves off the grid. Everyone else is going to have to pay more for distribution service. And so therefore, we're going to put a like $50 fee on everybody who has solar. And as he pointed out, that has now fallen finally. But that's not the only thing that people are doing to keep solar out of the market. As he pointed out, some utilities are more pro and some are less in favor of solar. One of the ways in which you can get solar is you can certainly buy your own system and put it on your own roof. But practically speaking, a lot of people can't really afford to do that. So they get a third party to put it onto their roof, and then they pay on a monthly basis. They're actually buying this, they're sort of paying a lease service to the provider of the solar panels. Now, if you're paying a flat amount, just as if you had bought it yourself, you're also then taking the risk as to how much these panels will actually produce. But a way you could get around that would be, what if your solar provider said, hey, I'm going to put the panels on your roof, but instead of you paying me a flat amount every month, you can pay me based on the amount that's actually being generated. So essentially, you're just buying the service from the person who's provided, you're buying your electricity from the person who owns the panels on your roof. So 3 cases, actually, I love doing this in class because I get different groups of students to read each of these 3 cases. There's one in New Jersey where someone said, hey, is this permissible? Is this a problem? It was a non-contested case. New Hampshire has competitive retail service. Went through without a problem. Nobody intervened. Nobody said a word. Commission said, yeah, sure, fine, do it. In Iowa, where the utilities have jurisdictional or have the right to be the exclusive provider over different areas, this went all the way up to the Iowa Supreme Court. And after a lot of debate back and forth, the Iowa Supreme Court said, yeah, we don't think this is actually a utility service. This is a contractual service between the person who put the solar panels on the roof and the person that owned the roof. And, we don't see this as being a utility service. It's fine. It can go ahead. The same fact pattern in North Carolina? No. If you do that, you're a utility provider. You are barred from doing it. It is the ability to sell power is exclusive to the utilities that have the franchise service area. Same fact pattern, 3 states, 3 outcomes. So we haven't seen that battle yet either. Again, as long as we have people that have a right to sell or feel they have some exclusive right, you're going to continue to have those competitive pressures that will slow down this transition that we would like to see happen. Just watching the time here, because there's so much here to talk about. Let's see. Oh, microgrids. I love microgrids. So this is a perfect example of where what we're seeing is actually a conflict between new technologies and old laws. Kind of similar to the problem we saw with the Federal Power Act of this one. This one's not a jurisdictional challenge. The problem here is that, first of all, let's define what a microgrid is. A microgrid has to be an area that you can isolate from the rest of the grid. And therefore, within it, it needs to have both generation and something that's consuming the generation, what we might call load in the parlance. So for example, if I have a solar panel and a battery, and I'm a homeowner that uses that, I'm not a microgrid as long as I'm kind of connected with and working with the grid. But if I can isolate myself and continue to operate, which requires a whole bunch of cutoff switches and stuff that are so expensive, most people don't do them. But if I were to do that, then I could be a microgrid. Now, practically speaking, we've had microgrids for a long time. They've been happening on college campuses, industrial sites, people that have a sophisticated operational staff that can handle their own generation, operate it, and handle the cutoffs and all that. And during Superstorm Sandy, in particular, the campuses of Princeton and Rutgers stayed up and running when everything else around them was black. So this led to a lot of interest in microgrids. And in particular, we saw a lot of the, some of the state legislatures, particularly in New Jersey and New York and Connecticut, said, we want to incent people to create these microgrids. We're going to provide money. We're going to provide grants to, for example, municipalities, set up town centers so that next time we have an event like Superstorm Sandy, the police station and the hospital and the school that can be used as a shelter will all be part of the same microgrid, and they can all operate to get, they can stay up and provide emergency services. The problem with doing this and why we have not seen more of these multi-user microgrids go forward is, once again, same problem we just saw over with the Duke story. Are you providing distribution service? Are you intruding on the space of the utility? Are you being a utility when you provide service to somebody other than yourself? So what's happening right now in the microgrid world is that we're seeing lots of microgrids emerging where there's a single customer. Again, an industrial site, a college campus. What we're not seeing is these ideal visions in which, multiple people would be served off of the same microgrid. So again, we have the technology, physically we can do it. Transactionally, we can do it. These people could all be willing to participate in the same microgrid and pay for the service. But from a regulatory and legal perspective, our laws haven't caught up. Now, I will say that here in DC, we are actually now looking at the microgrid issue again. Earlier this month, the PSC put out some definitions for a microgrid. One of the pieces that's troubling about it, again, is that they have this concern, and this comes out of opposition that PEPCO has raised to prior proposals for microgrids. They are concerned that if you're providing service to another party, that you have to be regulated as a utility. Now, one of the problems this particularly creates is that right now microgrids often are being provided as a service. So for example, even if I have a campus and I just want to serve myself, if I contract and have Jared be my provider of my microgrid, so he's going to come, he says, yeah, no problem. I'm going to install it. I'm going to own it. I'm just going to, provide the service to you. Welcome to the world of being a utility. No problem. You'll just have to file a lot of reports. You'll be regulated, your rates. No, it's no problem at all. So one of the other obstacles that we're finding on the side of when we get into the legal and regulatory world. Let me skip up to, oh, by the way, those do sometimes hit the courts in odd ways. There's actually one out in California that the argument there was that the entity who wanted to provide this service was told by the utility, well, you should just do net metering instead. And instead, what they ended up doing was ultimately, at the end of the day, they didn't get the microgrid they wanted. They found out the net metering wasn't as profitable as the utility had led them to believe. And so they tried to bring a fraud claim against the utility. It didn't fly. The court said, you should have read the tariff. The utility can only charge you whatever's in the tariff. So if you thought that they were misleading you, that's because you didn't read the tariff. I think this is really what Scott had led to earlier. Again, this transition, we're going to be seeing all of these issues arising as we move to this more complex system. I want to touch for just a second here on pipelines and some of the issues there. First of all, these are actually two of my vacation photos. I vacation in other places. The top one is actually the the Trans-Alaska pipeline. And for those of you students of history or were alive during that time, you may remember in the 70s, all the environmental arguments about why we should not be building this pipeline, part of which had to do with pumping the oil in the first place, and then secondarily crossing Alaska. And that did create some compromises. It's raised so that wildlife can migrate under it. It's raised, some of the stuff got uniquely patented. It's structured so it doesn't affect the permafrost. The heat doesn't transfer from the pipeline downward. But that pipeline's actually in danger now, danger of shutting down. And the reason why it's in danger of shutting down is because of a lack of throughput. So didn't get shut down for environmental reasons. It's economics that are, again, going to come and hit that. On the bottom we have, and it's not the best shot, I'm sorry, it's a little far away. But that is a train of cars hauling oil. North Dakota, as you may know, has become this hotbed for producing oil and natural gas. Actually, it's not producing the natural gas, it's mostly flaring the natural gas because it doesn't have pipelines. It also doesn't have pipelines for the oil, so it's putting it on trains, which are then being hauled by diesel. So when I see environmental groups congratulating themselves on having stopped the production of oil by stopping a pipeline, it's like, no, you stopped a pipeline, not the production of the oil. As long as there is an economic reason to move it, there'll be a way to move it. So again, this comes to how do we find that sweet spot where we do it in the least environmentally challenging or least environmentally harmful way. I'm not saying that I'm an advocate of pipelines, and certainly there's a big role for environmentalists in making sure that we put them in the least sensitive places possible. But as we think about the future of moving into hydrogen, carbon dioxide, these are all things that are going to need to move by pipeline too. And in some cases, we can't actually repurpose the same pipelines because, for example, pure hydrogen apparently does something to the kinds of pipelines that we use now for oil or natural gas, so you can't just repurpose them that way. So we're going to still be struggling with this problem of how you transmit or transport our energy products and where we're going to be able to do that. I do want to touch just again briefly on hydrogen. There's a lot of interest in this area. There's some incentives for it in the Inflation Reduction Act. There's a couple of interesting issues that I think are likely to come up with respect to hydrogen. One is who gets to regulate it. There's been actually a fantastically helpful article just written, published in the Energy Law Journal about the jurisdiction. Seems to be no question that hydrogen pipelines would be regulated, but the question is whether they'd be regulated by FERC or regulated by the Surface Transportation Board. So we're going to still see that play out. There's also all sorts of definitional issues that come up as we think about all these new products that we might be using. I just make reference to a recent case here, Vital versus the US. The plaintiff sued the US because it was seeking $8.8 million tax refund on the basis that it claimed that butane was a liquefied petroleum gas and therefore qualified for the tax credit. Court said no. That was the Fifth Circuit. So as we keep trying to take our new products and put them into our existing definitions, we're going to keep having that problem. Do I have time to just raise one other? So another problem that the public service commissions, I think, are going to be having, that's going to be another really interesting area. If we look at DC, for example, there's an effort to phase out the use of natural gas. And we talked already a little bit about the electric system, the distribution system. So as people move on to solar, they still really need to be, unless they truly are isolated and are operating as separate grids, they still need to be connected to the distribution system. And so, yes, they do still have to pay, just not exorbitant fees. But the gas system is a little bit different. As we phase people off of the gas system, we still need the existing we still need the existing gas system to provide for the people who are connected. And it needs to be safe because gas pipelines blowing up is really bad for a lot of different reasons. So who's going to pay for that? Where's that money going to come from? Now, remember, if you're the Public Service Commission, you're regulating in the public interest. You have an obligation not only to consumers, but to the companies. So can you just put the gas distribution service out of business? How are you going? I don't have an answer for this question. It hasn't hit the courts yet. But to me, that's going to be one of the most intriguing questions. How do you make that transition in a way that makes any kind of sense? And I have to say, I have a gas stove and I love it. But in fact, there was a group of chefs out in California that sued because they argued that this effort to try to push them onto electric was harmful to their business. So I think that just really brings us down to the end and the question about the, I just happen to like this combination of the meter with the I pledge allegiance to Mother Earth, one planet, indivisible. Again, it was a vacation photo. But I thought it illustrated these points of friction. State policies competing with federal rules, the problem of competitors and each arguing to maintain their territory, and this problem of old laws and new technologies and how those will intersect. As Scott did, just touching on the fact that jobs are going to be changing. And so I just want to close by commenting that I think one of the most remarkable things about the Inflation Reduction Act, and one of the things that gives me the most hope for it, to some respect, it continues a lot of the things we've seen in the past, such as tax credits. But really, since the TVA Act, we've really never had an energy policy that has tied together both the policy side and the jobs and the economic development the way this one does. There's a lot of incentives in here for people to come in and put in new plants, new manufacturing facilities, for example, manufacturing solar panels in places that are being harmed by the loss of some of the more traditional energy areas. There's also money in there for environmental justice, quite a bit of money. So from my perspective, I think that's really probably one of the most positive things and one of the things that gives me the most hope that this will be a little bit different than some of what we've seen in the past and may help accelerate things by changing hearts and minds.
Thank you so much, Donna.
Oh, questions?
Yeah, we'll have some, see first if there's a couple questions just for you, and then we'll go into a more general discussion. You really kind of anticipated the question I wanted to ask you started off by talking about the balance of factors underlying energy law, the financial interests of the companies and supplying energy. And I wanted to ask you if you had started to see in any of the cases, even in any arguments being made, a shifting of that test in the law or the way the law is constructed.
Not really. I mean, that's it's an interesting question as to what is in the public interest.
Exactly. We have a whole new set of factors, understanding there's all this momentum that shows that at least some of the public is interested in shifting to renewables. There are all these other factors that affect the economy. So I was curious if it was starting to be reflected in the jurisprudence at all.
Not as much as you would think. Historically, the public interest has been relatively narrowly interpreted to sort of still be within that realm of rates, terms, and conditions. So for example, going back to this, I think 1964, there was a case in which FERC was asked to find that utilities that discriminated against people of color would not be able to recover in their rates certain labor costs. And the courts said that's worthy cause, but not within FERC's scope of public interest. So from a state by state basis, it depends. I mean, some states actually are broadening it and they may actually require you, their public service commission to think about environmental impacts. But these regulatory commissions are creatures of statute. They do what they are told to do. And so until you have broadened what that meaning is of public interest and what they're regulating, and most of them will not independently say we have to do this for environmental reasons. They may take environmental into account when they're thinking about, what is the least cost path forward for a utility, but they usually bring it back to rates and service quality issues.
Okay. Yeah, please go ahead.
Yeah, Lynn Schlosser, American Council of Engineering Companies, and you flashed one slide that had a slide that had the word reliability on it.
Yes.
And,
okay.
and to me, it's such a big item.
It is.
And the jurisdiction of FERC over NERC, what that means, what's it mean in the future in the energy transition? Because all this electrification, the stampede, the gold rush of IRA, reliability seems to be lost on people, but for NERC and warnings earlier in the summer, summer's not over, but ERCOT and winter peak issues in the Northeast, there are big concerns about electrification, energy transition, and meeting those, meeting reliability concerns. That's a cost, okay?
Yeah, no, I agree with you completely. I did flash over that. When we talk about the Federal Power Act, it was actually amended significantly in 2005. And one of the things that changed was giving for actual jurisdiction over reliability, but it works in a kind of an odd way. Prior to that, starting with the blackout in 1965, utilities had sort of come together voluntarily and created something called the North American Electric Reliability Council. In 2005, FERC was required to select an electric reliability organization, which NERC as it's known, immediately reorganized itself into the North American Electric Reliability Corporation and applied for the job and got it. And what they do is NERC will propose rules that go to FERC, but FERC can't change the rules. That is, they can approve it or they can send it back to NERC. But that is basically how we're running our electric system. Now, on one hand, it's really remarkable because it is there's not a lot of industries that sort of do that, so thinking ahead, having a standard that people have to live up to, but it's also something of a minimum standard. And as you point out, we are stressing the system. When we talk about electrification, I mean, frankly, I'm a little concerned about the rush to electric vehicles and electrification generally, because first of all, as you've seen, we still have a lot of generation that is not renewable. We're still running most of our system on fossil fuels. And second of all, I mean, the system is not always perfectly reliable. And if we put all of our eggs in one basket, I think we have issues. So we are continuing to stress it. It is a big issue. Yeah, I'm not sure what else I can say in response to that, other than I agree with you.
Great. To kick off the more open discussion session or section, I have a question for each of you. In thinking about this transition that we're undergoing and the challenges that you see, our project is hinged on the understanding that environmental law or climate law is based on science and technology, and thus the law and policy experts, judges, whoever they are, need to understand some elements of the science or technology, and vice versa. Well, so I would ask each of you from your perspectives for the other discipline, which are the, as a legal expert, which are the technology or science aspects of this sector that you think are most important for law and policy experts to understand, and vice versa for you. What are the legal constraints that you see when you're thinking about how to advance things that you work on?
Well, I think that overall, I mean, even understanding the climate science and understanding what is possible and what is not possible is really critically important. And again, understanding the technologies is very important. But again, most of the problems that get in front of the courts end up being these bizarre things about jurisdiction. And it's not really getting to the heart of this problem of how are we going to affect the change. So I'm not sure if it's really the problem of the courts. I think it really is a problem of needing more direction from policymakers that goes to also changing jurisdictional boundaries, changing the mandates of the public service commissions and the regulators to make this a piece of what they are supposed to be doing. Absent that, I don't know that you're going to see this kind of change again coming out of my end of it. But I do think it is important they understand what's possible and what it actually costs. And it's really kind of the regulators need to understand more about what it would actually cost and what could be done if they worked on it a little more.
I teach a course, a graduate course in the summer called Renewable Energy and Critical Infrastructure. First in the country, actually. And one of the things I try, and I teach seminars at National Defense University of Fort McNair and Industrial College of Armed Forces. And at the military, understand that if you have 1 in 500 chance of something happening, that doesn't mean it cannot happen tomorrow. That's statistics. And so this idea that 1 in 500 is far away, which is how most of our regulatory commissions and political system handle this, and many cases utilities, you think, well, it's just not going to be very common. And of course, what happened in Texas with the entire grid predominantly going down in a winter was predicted by scientists as a not in 1 in 500, probably 1 in 30 possibility. And it was poo-pooed. And then I was getting calls by the press of saying, oh my God, first of all, it wasn't the wind turbines. That was nighttime energy, 20% of their energy at nighttime. That didn't do it. It was that they frankly didn't winterize their pipeline pumps, both natural gas and water. You need water to create steam. Obviously, a lot of it was natural gas. And it's not like cars are wrong and horrible because they weren't winterized. You just put antifreeze in your vehicle to make sure it can run in the winter. So what climate change is going to do is create new costs. And what we have to do in science is create the understanding that these long-term probabilities are going to be more frequent and you better prepare for them. What's going to happen in the legal system is who's going to be liable for the damage of all that. and who's going to be liable for the costs. Should customers be liable that the utility industry in Texas was warned several times by prestigious groups of people saying, get your act together? And do you want to raise our rates, or do you want your investors to take the hit because you made a bad corporate decision? And so you're going to see more and more of that, which of course is going to drive more and more technological solutions that have less propensity to crap out. And that's why you're going to see these microgrids and zero energy buildings and self-powered infrastructure, which is what I do, because the system is going to be quirkier. And those different sectors are not going to want to assume the liability. That's what the legal system is really used for. Who pays? Nobody wants to pay. So that's the game I see. And of course, during technology changes, i.e. the phone system, i.e. the internet coming in, we have done this before. It's painful. Businesses are going to lose out, but at some point it's going to start coalescing and we're going to get a rhythm in it. And that's the play here.
One and then two.
So two sort of related questions. I understood some from what both of you said, that storage capacities have gotten enough better, that there is a lot more ability to store power from renewable energy than there
Well,
was.
for all energy,
Okay.
including renewables, yes.
Fair. But my follow-up question is related to renewables in particular. Is that now to the level that individuals or small groups of individuals could store power for themselves? And related to that, like if a small cluster of rural homeowners like wanted to get together and not charge any money, but all have solar panels and share it amongst themselves, could they do that, or would they be in danger of being deemed to be, like if it's a bunch of, I'm from Oklahoma, if it's a bunch of rednecks out in western Oklahoma that want to get together and share power?
Well, there are three answers to that question. I'm going to give it to Donna in a second. The National Rural Electric Co-op Association has been putting energy storage at the end of long distance power lines. And there's always been a problem because when you're down at the end, particularly when the system's stressed, your power starts flickering, you get bad power quality, you ruin appliances. And so they've been doing that. Plus, there are a lot of times the lines go down. And so there are pathways for utilities who want to address it with their customers to do that. On the Scott-Sklar end, and when I moved in Arlington, we have a lot of power outages because we have a lot of trees. And I didn't realize that how many times the lines went down. And so I did energy storage so my basement wouldn't flood. And of course, then I got crazy and, you get opium and you go the whole way. So, so there are business owners and hospitals and stuff that are doing it just to protect themselves. And they can do anything behind your corporate fence as long as you meet certain code standards. And what you're talking about is, can there be a storage co-op? And I'm finding there are some allowed, mostly municipal utilities, some rural utilities where they'll just sort of look the other way and let it happen. And now I'm going to pass the microphone over to Donna to answer the other part of that question.
Yeah, no, it's actually very similar to the community solar question. Yeah. So again, it's going to be area by area. Certainly the rural co-ops have actually started some of that effort. Here in DC, for example, there's a specific law that permits community solar. They call them community something or other facilities. Yeah. And there's slightly different rules than if you have it on your own rooftop, primarily having to do with compensation, but it is permitted. What you're proposing, where multiple people would actually own it and be sort of self-supplying, that might fly better under certain jurisdictions than others. Cooperatives are a little bit fluky because some states regulate them and some don't. And so again, the co-op thing might work in some states, might not in others. It's also completely feasible because often if you're doing something like that, you're again, probably going to have somebody who's sort of the lead. So you could also run into the same problem that we saw in North Carolina where the person who's actually running this thing and you're providing power to other people, and that makes you a utility. So I'd say the answer is really all over the board. It could be any of the above. There are some states, though, that are specifically looking at being able to provide community solar. That's not as many as you would think, but it's happening even in states where it isn't permitted because they're doing it essentially where they're all a group of people self-supplying.
To add to that, though, California, because of the forest fires,
Oh,
there are
yeah.
some communities have come in and said, we want a battery bank at our local substation. And we want to figure out a way to do it either through the utility, if they don't want to do it in concert with them, but not, well, we'll finance it. You know, the corporations and the homeowner associations will pay a fee to a private corporation. They'll put in the battery bank. They'll do it. So, you know, it meets the interconnection standard to the substation. So the regulators, the utility are comfortable. And they're sort of looking the other way on some of that. And of course, they're doing a lot of microgrids beyond that. So I think in areas that are stressed, it's going to come in first. And then I think at some point it's going to be regulated and streamlined because there's no way around it, actually. That's the problem for regulators and utility companies.
Yeah, actually, in North Carolina, there have been several microgrids that have gone in owned by the utility, but particularly to solve the problem that Scott's pointing to. There's something way at the end of a line. They can't protect it from forest fires. They can't really maintain it very well. And so that's actually the better option. I have a question for Scott, actually. Storage. So when we talk about batteries, very effective for being able to smooth out, say, day to night, you know, over a short period of time. But correct me if I'm wrong, but we don't have a lot of technologies that are good at, like, I can, you know, store energy in August and use it in December.
No, we don't have the multi-month kind of thing. I mean, we do have it for weeks, but not months. That's correct. But there's interesting technologies coming out. And I just saw for the first time commercial grade flywheels that used to be very expensive. And they have a capability. There are some thermal storage technologies that potentially that are starting to get better, but they're still at the high end. But again, as this reactive grid evolves, there's economic drivers to really make them smaller, make them more modular, make them more affordable, and make them smarter and easier to integrate into a grid system or a building system or a campus system. So, good point.
Yeah. We had a question there.
You mean me?
Yeah.
Edward, yeah.
I'm sorry, Edward.
I was wondering, you talked a bit about how energy, you think that with energy commissions and courts, they're sort of prevented from really dealing with the issue, the issues by jurisdictional type questions. But does that mean you think they really, do there only people make those decisions really, the judges and such really understand the scientific issues involved very well, or?
Judges understanding what the commissions do?
No, I mean, the judges and the commissions understand either
The technology.
scientific issues involved very well.
It's hard to generalize. I mean, I would say that there are some commissions that have very good staffs who are actually very well versed in this. And then there are other commissions that running on bare bones where they have absolutely no idea what the technologies are doing. With the courts, it's a little different because, and again, this sort of goes to the politics of public service commissions. A lot of them, I think as Scott, you mentioned earlier that, you know, often they just kind of look to the utility and say, what's the answer? It is true that a lot of our commissions are sort of in the pockets of utilities. Others are very independent. With courts, I think that they tend to be a little more independent because this isn't the area they play in all the time. But they are very much dependent on the information that's presented to them. It's how well it was briefed, how good were the experts, how much information did they really give. So I think it's really incumbent on the lawyers to some extent to inform the courts about the issues and to present it in the way that is, most appropriate for whatever the case is. The courts are never going to become experts in this because they see case here, case there, along with all the other cases that they're seeing. So I think that's really kind of where I'd come out on that. The commissions should get smarter.
Yeah, here's the question.
Yeah, you go ahead and then Paul's got one. Go ahead.
I'm gonna reveal a degree of cynicism and then perhaps hope that the climate change issue will change it. In the relationship between the public service commissions and FERC, and year after year in the state of Maryland, we are deluged with various pieces of legislation attempting to support one form of technology or another. And, the utilities and the environmental lobbyists battle against each other, but it's kind of, oh, well, that becomes a FERC problem and it's going to raise your rates, or, oh, no, that's going to raise your rates. And this elusive generation versus distribution. I mean, generating is nothing. It's going to be distributed at some point. So it's where is the line drawn? So I have to say that in watching these debates evolve over time, it's a little bit like the evolution of gambling laws and is political. I mean, depending on who the political group is that's favoring this or that or the other thing, they will find a way to squint at it and make it work. And often the Public Service Commission.
That's not cynical, that's real.
And often the Public Service Commission is to some extent asleep at the switch. So I'm wondering, as this jurisdictional question evolves, we now have shown scientifically, we really do have a public interest in dealing with carbon generation. And so this ooey gooey question of, will it raise the rates? Will it not raise the rates? Well, it depends on, is it generation or is it distribution? Will there ever be a vehicle by which we can say, okay, carbon, sort of the carbon issue, I don't want to use the word trumps, but the carbon, that issue will trump it. Is, or am I just
Well, let me
illusory?
just say, I mean, first of all, I 100% agree how you characterize the situation, but in the states that have been kicked in the teeth by catastrophic unplanned events more than once, you're getting it built in, and there are different verbiages, of course. I'll just use the word risk at the moment, and that's fine. And so that's starting to do it, but it's only in the places anecdotally that get kicked in the teeth. And then the good news, there is some good news, sort of, is that big states like California and Texas, when they're kicked in the teeth, and I guess Superstorm Sandy with New York and New Jersey in those days, well, that, they said, a couple more of these and we're really not functional at all. And so I am seeing risk written into the regulatory planning and implementation path with the understanding somebody's going to have to bear the cost. And I keep on saying, I'm doing this quite often on infrastructure, is, there's a private sector out here that can finance this stuff and finance it for less cost than what you're getting from the grid, but you have to create certain pathways to allow that to happen that don't necessarily. So why don't we look at places where, like Donna just talked about, where the utilities are having a hard time keeping their grid stable, and maybe creating sort of regional or area pathways where it can attract new technology, green technology, 100% reliable technology for certain segments that the utility is comfortable with because they have liability and it's going to cost them a ton of money to resolve. And maybe it's not part of their core business anyway. It is at the end of the line, or infrastructure that's far away, and they just don't want to have the expense of running wires every 4 months, and look at it that way. And I can't tell you right now how that pathway is going to go. I don't think either of us can. But these horrendous conditions are going to get worse, and they are going to have to deal with it, and people are going to have to pay for it, whether you hide it in rates or you hide it in, state, local government spending, or sometimes with the Fed bailing it out. Who knows? But somebody's going to pay for it.
Yeah, the only thing I would add to that, because I do agree with that, at the end, somebody's got to pay. And it really is what, when the Public Service Commission is saying, oh, that's too expensive, what they may actually be doing is just shifting the cost elsewhere. How do we pull in all those costs? I don't have an answer to this. But, for example, if you even think about making the decision between, say, wind and gas. Well, okay, we know that emitting, well, let's make it a little worse, coal, because that had been the choice for many years. You think about the impact on asthma and, just general health of the people around there, if the cost to coal miners, the cost, if you pull all those health issues in, then all of a sudden, wait a minute, this isn't very expensive at all to make that decision to go to the other technology that looks on its face to be more expensive. But those aren't within the bailiwick of what the Utility Commission looks at. They're looking at what costs is the utility going to incur. So when, for example, you require pollution control equipment on a power plant, you've now put the cost on the power plant, and it then becomes something the Public Service Commission considers. So until you incorporate these, so for example, if we had a carbon tax and the utilities actually had to pay that as they were generating, they would be making different decisions, and the Public Service Commission would pay attention to it because it's now their cost. It's in their realm.
Yeah.
But we got to figure out how to bring those costs into where they can be considered appropriately. And again, the cost of, a microgrid could make a lot of sense in terms of being able to help people shelter in place during a Superstorm Sandy type of event. But who's paying the cost of evacuating them? It's not the people who are going to pay for the microgrid. And so again, the costs are not in the same, they're not all in the same pool.
It's that universal problem of, for the companies that were looking at the cost, it's an externality. It's not on their books. None of this stuff is on their books.
Right.
To get it onto their books is the political challenge. I
Yes.
think that's what it is. It's a political challenge.
Yes,
Exactly.
100%.
Because the Public Service Commissions can consider anything if they have the jurisdiction to do it. But you've got to get it into their jurisdiction, and that's a legislative problem.
Good framework.
So I'd love to jump in on this a little bit because you mentioned carbon tax, and there was a really interesting piece that appeared in The Hill written by Gary Yo a couple of days ago, speaking about, who is, by the way, a climate scientist and an economist, and an author with us of a curriculum on climate economics. And Gary pointed out that the IRA, the Inflation Reduction Act, climate incentives for developing solar, wind, other clean energies are what he referred to as a shadow tax. They have the same effect as a carbon tax in those particular areas, in that there's a substitution that takes place in those particular areas. And what you're talking about right now, in the PUC's consideration, they're not having jurisdiction, is to say, points out a point that Gary was also saying, which is that it's a highly inefficient carbon tax because it does not, because it doesn't apply across the board.
Correct.
It's not
And
full
for
loop.
for the
Or end use.
end use. So I wanted to note that, but also note that there is in the IRA some provision for encouraging certain kinds of technologies. And note in passing too that if PUCs don't quite know how much the impact of their decisions are, perhaps they could benefit from some education of the kind that we're giving judges as well in the science and economics of climate change. Just a toss-off thought. What do you guys think?
Well, I just want to say, my view, because I do a lot of speaking to sort of the unconverted, right? I do a lot of military stuff and industrial parks and farmers, so generally conservative, business-oriented population segments. And I don't talk about climate. I talk about risk. And again, in this class, I
Right language.
Human error. There's a huge amount of human error in energy, including utilities. Oh, and animals. Animals bring down the grid about 15 to 20% of the time.
Squirrels.
Raccoons, elk,
Right.
things like that. I have a couple of great fraud pictures too. Well, let's give that up. Terrorism, both cyber and actual. And then these, shocking weather events, but geological events not tied to climate change, like earthquakes, right? So, and there's more. I don't want to list all of them, but we have a lot of risk. And, my instinct is there ought to be a risk tax. And if you do a risk tax and you include all of that stuff, then all of a sudden it's not the, greeny, commie enviros. It's, the terrorists and people trying to hurt us and animals that are somehow trying to go after us,
Interesting.
and all this stuff. So,
So it's the right framing you're
yeah,
talking
it's the
about.
right framing. And I think as a society, we need to do that somehow.
Mhm.
And why I love to do the military project, because they understand risk. That's their whole goal.
Right.
Money is important, but the end day is to keep soldiers alive and to meet mission. And it would be sort of nice to say, hey, we want to keep the public alive and meet mission with reliable energy. It's clean. And by the way, I do want to add water, the extraction, conversion, use of energy is the single largest use of water, more than irrigation. And both use about 95% of our water. And we're having less clear water. So what we do in energy really impacts the next great challenge that our societies are going to have to deal with. And that's risk too. That needs to be right up there on the list. So.
Thank you.
I would just add a couple of comments. One is that most of our energy policy for probably the last 5-6 decades has been in the tax code. We don't have an energy policy, we have tax policies. So I had an ex-partner who said, you cannot talk about energy without having me in the room. So I think that your points are well taken. It would be better if we actually did the more effective tax. But the other thing, there is another way that commissions can approach this, which is to look more at the risk issues and to put it back onto the utilities in terms of making decisions and how they allocate what they're allowed to collect on or not. So, to the extent they have some ability to push some of the risk back onto the utilities and their decision making, it's not usually where they've been, but we have been seeing efforts to move more towards performance-based types of recovery schemes. So the utility is required to live within a certain budget and to meet certain goals within that budget, and they're allowed to collect on that, but they have to meet these goals. And if they don't, they get a reduction. And if they meet them, it's over. It's still cost-based, but it's kind of with a little bit of a twist. It's been used somewhat in Great Britain with mixed results. It's catching on a little here in the US. I think we really need more experience to see if that works. But that's one of the ways in which you kind of get the utilities to play too.